Good afternoon. Welcome to the Heritage Foundation and our Douglas and Sarah Allison Auditorium. We, of course, welcome those who join us on our heritage.org website as well as C-SPAN network. For those in-house, we would ask that courtesy to see that our mobile devices have been silenced or turned off. For those watching online, you're welcome to send questions or comments at any time, simply emailing speaker@heritage.org. And of course, we will post today's program on the Heritage homepage for everyone's future reference as well. Leading our discussion and welcoming our special guest is David Kreutzer. Dr. Kreutzer is our Senior Research Fellow for Labor Markets and Trade. Prior to joining us here at Heritage, he taught economics at James Madison University from 1984 to 2007. He also served as director of their International Business Program. In 1994, he was a visiting economist at the U.S. Food and Drug Administration, and in the early 80s, he was also a visiting economics instructor at Ohio State University. Please join me in welcoming David Kreutzer. David?
Thank you. Well, I want to welcome all of you here and online and watching on television to our event, Protecting Public Employees' First Amendment Rights, Major Cases Challenging Abood. The way we'll work it is I'm going to give the bios, brief introduction of our guests. Then I will turn it over to Colin, and each speaker will speak for roughly 10 minutes, and then we'll have plenty of time, I hope, for questions and answers afterwards. Rebecca Friedrichs served as an elementary school educator, Rebecca Friedrichs served as an elementary school educator in Southern California for 28 years. Since the first day of her career in 1988, she was concerned about the policies and politics of the teachers' union she was forced to join and financially support. As a result, she was lead plaintiff in a seminal federal lawsuit attempting to restore the First Amendment rights of free speech and free association to millions of public sector workers. Her suit, Friedrichs versus California Teachers Association, filed with 9 other teachers and the Christian Educators Association International, brought suit against the NEA, the CTA, and 10 local unions and superintendents. Rebecca's editorials have been published in foxnews.com, the Orange County Register, the San Diego Union Tribune, and several other print and online outlets. She's been a guest on many radio shows across the country, has been interviewed by numerous print and news outlets, including Politico and the National Review. And she has appeared on CBS News, NBC, and Fox News and Fox Business News. She now serves as a fellow at the State Policy Network. I'm glad you're here. Thank you. Next is Jacob Hubert. Jacob Hubert is senior attorney at the Liberty Justice Center. He litigates cases to protect economic liberty, the First Amendment, and other constitutional rights in federal and state courts in Illinois. Jacob received his BA in economics from Grove City College and his JD from the University of Chicago Law School. After law school, he clerked for Judge Deborah Cook of the United States Court of Appeals for the Sixth Circuit. He then worked as a litigator in Columbus, Ohio, before joining the Liberty Justice Center upon its founding in 2011. As an adjunct law professor, Jacob has taught at the Chicago-Kent College of Law, the Ohio Northern University College of Law, and the Ohio State University Moritz College of Law. He has spoken to Federalist Society chapters at law schools across the country on topics including economic liberty and judicial selection. He has authored a book, Libertarianism Today, and his writing has been published widely in scholarly, professional, and popular publications. He is admitted to practice in the state of Illinois as well as the United States Supreme Court, the United States Court of Appeals for the Seventh Circuit, the United States Court of Appeals for the Sixth Circuit, and several other federal courts. Next, but not next on the dais, is Terry Pell. He's at the end. Terry is president of the Center for Individual Rights, a nonprofit public interest law firm located in Washington, D.C., dedicated to the defense of individual liberties against the increasingly aggressive and unchecked authority of federal and state governments. Mr. Pell received his PhD from Notre Dame in 1996, his JD from Cornell Law School in 1981, and his BA from Haverford College in 1976. Prior to working for CIR, Mr. Pell worked as an attorney with the Arent Fox Law Firm from 1985 to 1988. Mr. Pell was a Deputy Assistant Secretary for Civil Rights in the U.S. Department of Education. He later served as General Counsel and Chief of Staff at the Office of National Drug Control Policy. He joined CIR in 1997. Colin Sharkey is Executive Vice President for the Association of American Educators, a national non-union teachers association. Colin oversees the day-to-day operations of AAE, including providing members benefits to tens of thousands of members nationwide, expanding membership each year, and working with partners on education reform and labor reform projects. Colin also oversees operations at AAE's 501c3 Support Foundation and AAE's growing network of state chapters. In addition, Colin co-founded and co-leads National Employee Freedom Week, which is this week, a national information campaign and coalition now in its 5th year, highlighting the rights that employees have regarding union membership, including opting out, objecting, and joining non-union alternatives. Colin has been interviewed on national news programs and by numerous radio hosts. Before joining AAE in 2008, Colin served in the Coalition Relations Department here at the Heritage Foundation and at the Intercollegiate Studies Institute's Collegiate Network. Colin graduated from the University of Notre Dame, and I'm going to ask him to take the dais now and take over the program until Q&A. Thank you all.
Thank you, David, and thank you to the Heritage Foundation for agreeing to host this event, and thank you to all of you for attending, and everyone who's watching via the live stream and C-SPAN. I appreciate you tuning in, and thank you to the other panelists who made it to DC in August, although the fact that you're here, I think, means you didn't win the Powerball last night, so I'm very sorry. Rebecca, you would have come anyway, I think. You're just a true believer, but yes. So welcome to National Employee Freedom Week. It's all week, August 20th through the 26th. I do have to start out to apologize. I have to admit that National Employee Freedom Week, as great as it is, had nothing to do with Taylor Swift dropping songs at the end of National Employee Freedom Week as a celebration. I know, Starley, you're disappointed that that wasn't us. The solar eclipse was, though. We set that off as a great start to the 5th annual National Employee Freedom Week. So as David said, my name is Colin Sharkey. I'm the Executive Vice President of the Association of American Educators. AAE is a non-union, non-profit professional teacher association. We serve tens of thousands of members throughout the country in all 50 states, in all school environments, especially public district teachers and public charter teachers. They get their professional association benefits from AAE rather than joining the union. But we don't participate in collective bargaining. We don't support strikes. We don't engage in partisan politics or support elections. So we're much cheaper than the union as a result. You can learn more about AAE at aaeteachers.org. AAE was founded as an alternative to the usual, the only other offer really for teachers if they wanted their liability insurance and professional association benefits. There were National Teachers of the Year who thought that that was not fair. Teachers deserved an option. We asked so much of teachers that it was unfair to kind of force this one expensive, brings a lot of baggage with it option. So AAE was founded. And we found out very quickly, even though we offered great benefits, found out very quickly a problem. And that's that there are many teachers who don't have the choice of their association. We enjoy freedom of association in America, but for teachers, they can be forced to fund an association they don't want to belong to, and therefore can't join an association that would better serve them or they believe would better serve them. Not only is that a problem, that they can't choose their association, but if they do have that right, they may not know they have the right to exercise it, and if they do try to exercise it, it's often very burdensome and complex and challenging to do, not to mention the pressure that they may receive. So AAE, just as a result of trying to be an option for teachers, a professional association for teachers, fell into the role of trying to expand employee freedom and defending the freedom of association. As a result, we're a plaintiff in one of the lawsuits that you're going to hear about today. In fact, all the plaintiffs in that case are AAE members. You'll hear about it at the end of the panel. And 5 years ago, AAE co-founded National Employee Freedom Week. This was an effort to concentrate attention in a positive, pro-employee, focused way to inform America's workforce about this problem, as well as what rights they do have and how to exercise them. Response has been wonderful. If you ignore the four-letter word responses that we get from some people about what it is we're trying to do, I've been called much worse. I've played Call of Duty online, so they really don't have anything on those kids. But National Employee Freedom was really just an opportunity to concentrate a coalition of organizations to draw attention to this. For the most part, employees just don't know that they have the right, and if they do know, they don't know how to exercise it, and they're afraid to ask. So there really was just nobody out there. AAE and the Nevada Policy Research Institute, which is a libertarian think tank based in Nevada, recognized this need and formed this coalition 5 years ago. And events like this and op-eds and information campaigns and billboards and a website and Twitter and Facebook are all part of that effort to inform America's workforce about the rights they do have. One other element of National Employee Freedom Week, by the nature of talking about what rights employees do have, we end up talking about what limitations still remain on employees. And this panel is talking about one significant limitation, one significant burden that remains on public employees, and the lawsuits that are challenging that because it infringes upon the First Amendment rights of public employees. So that's what we're going to be talking about today. My goal for the panel is that you're more familiar with that significant limitation. It's the Abood Precedent. We'll each be talking about it by the nature of these lawsuits. I want you to be familiar with that, as well as when you hear these case names again in 2 months or 6 months or 12 months, you'll know the import of that case, why it's being discussed in the news at that stage, and what could happen if it's victorious. So before handing it over to the first panelist, I want to give a little bit of historic context to how we got to the stage of needing these lawsuits. And it's going to be surprisingly brief. The labor history in America is rich and troublesome and fascinating, and it's certainly worth being familiar with, but I'm going to scan through a few key points to catch us up to when these lawsuits were deemed necessary and started to proceed. So in 1935, Franklin Roosevelt, during the Great Depression, following decades of disruptive strikes for coal and railroads and violence between union supporters and opponents, the pressure had built along with the Great Depression to support major labor legislation. The National Labor Relations Act in 1935 essentially created the private unions controlling essentially the workplace. They had control over who would be working there. They could collectively bargain, they could strike, they could organize. It was very union friendly. Not surprisingly, result of that legislation, the unions grew in membership and in power. Also not surprisingly, within about 12 years, popular opposition to union power had grown so much that Democrats and Republicans together overrode a veto by President Truman to reform that act to restrict just a bit the power that had given the union. There was a wave of strikes following World War II, very unpopular, significant strikes, and popular opinion had been so significant that the Democrats in Congress, along with Republicans, ignored the wishes of the president's veto and passed the Taft-Hartley Act. What Taft-Hartley did was ended what was known as the closed shop, essentially a form of control the union had over the workforce, and allowed for what became the agency shop. You're going to hear in these lawsuits the importance of this word, the agency fee. Other coverage of these issues may call it forced dues or compulsory unionism, fair share, but it's essentially that non-members in unionized workplaces can be forced to pay the equivalent of dues of belonging to the union. As you can imagine, for the most part, people would just stay in the union if they're being forced to pay anyway. The first 1935 law gave an out for religious objectors, but at this stage it was still essentially, if the union had taken over the workplace, everybody was paying for it, whether they liked it or not. That was private workplaces for the most part, and not even all of them. It wasn't until the 50s and 60s that collective bargaining rights had been expanded to public workers. In 1958 in New York City, the mayor had expanded it to some of the public workers in the city. In 1959, the state of Wisconsin expanded it to many of the public workers there. Numerous states followed. President Kennedy in 1962 extended it to federal workers, or some federal workers, via executive order. Richard Nixon expanded that in '69. And very quickly, public unions started to outpace the growth of the private unions. I think even by 1970, the percentage of union members in public employment was greater than that in private employment. It used to be about a third of private workers were unionized. Now it's actually about a third of the public workers and single digits for private workers. It flipped very quickly following that extension. As a result, numerous workplaces became unionized, especially school districts. Many teachers today were not at their school when it first welcomed the union, and they really have never had a chance to decide whether or not they wanted to keep that union. There's no recertification vote. It just kind of has always been there. Rebecca, you've been an educator for, you were 28 years. Was the union there when you got there the first day?
Yes, it was voted in when I was a child.
So that was that wave, the 59 Wisconsin law, adding these unionized workplaces and maintaining the structure of agency. So in the late 1960s, early 1970s, some public school teachers in Michigan, where they had an agency shop law and they were forced to pay dues even though they didn't want to belong to the union, challenged it in court saying this is an infringement on our First Amendment rights. This is forcing us to pay for political speech, and we feel that we shouldn't have to do that. That became the Abood Supreme Court case that we're going to be talking about. That's the precedent. It's essentially the framework that we're under today. It's been refined some. There was a case in 1986 called Hudson that addressed some transparency issues. But the Abood Framework is essentially that forced non-members of the union, people who don't want to join the union, can be forced to pay almost the equivalent of dues, 80, 70, 80, 90%. Abood did allow for that little difference that was there. In 2014, Harris V Quinn started to challenge. There had been other challenges to Abood, but this lawsuit had started to challenge the framework that Abood, which is 40-year-old precedent now, was based on, that this is political speech. This wasn't a new argument. This is actually from the concurring opinion at the time by one of the other Supreme Court justices recognizing that collective bargaining is political activity and political speech, and you cannot force a public employee to fund that. The court went the way it did, but that had sat there as an opportunity, and it had been pursued in Harris v. Quinn. There was a reason why that didn't proceed, but then there was another challenge in 2016, Friedrichs v. CTA. With that, I'm going to turn it over to Rebecca to talk about what happens next in our story. So thank you.
Thank you.
Well, good afternoon, everyone. In 1987, I was a bright-eyed and bushy-tailed student teacher, and I had an outstanding master teacher, taught me everything I've ever known. But next door to us was a teacher that I have come to call the witch. She, every day, would grab these little children. She'd yank them by the arm. Typically, it was the poor, wiggly little boys. She'd get right into their faces and scream at them. She towered over them. I was 22. I was terrified. They were 6 years old, first graders. I can't imagine what they were feeling. But she abused them like this every single day. And this was just outside. I don't know what went on when the door was closed. But I went to my master teacher and I said, look, I'm learning about how to report child abuse, and I think I see some next door, and it's the teacher. And my master teacher sat me down and said, today, Rebecca, is the day you learn about forced unionism, teachers' unions, and teacher tenure. What I've come to learn since then is that teacher tenure works together with collectively bargained grievance procedures and quite literally ties the hands of administrators so that teachers like the witch are protected and the vulnerable children in her class are out of luck. Well, I thought that was wrong, and I didn't want to join this union. I didn't want to pay a union that put the protection of an abusive, who I call witch, put her job security above the safety and the education of small children. But I soon found out I didn't have a choice. I didn't have to join the union and pay their dues, but I had to accept the union's representation and pay their fees. They use a lot of little tricky language, so you have to pay attention to what it is they're forcing you to do. Some of their tricky language is they tell the American people, the unions tell the American people, well, Rebecca can opt out. Teachers don't like this, they can opt out. Really? Well, let me tell you a little bit about opting out. First of all, you can't figure out how to do it. They make the process very convoluted. When I went to my teacher rep and I asked her, how do I opt out? She said, oh, that's easy, just check a box. Well, here's what I found out about that. When you check the box, you have just asked the union to give you a rebate of the $20 a year you didn't know you were donating to the union's political action committee. So now you get back that 20 bucks, but you're still paying full union dues and you are a full member, paying for all politics and everything that has to do with the union. I think that's deceptive. So I started learning about how to actually opt out. When you opt out, you become something called an agency fee payer. This is how it works. As an agency fee payer, you pay 100% of the collective bargaining fees. But you have no voice in collective bargaining. I'm not even invited to the meetings. You have no vote in collective bargaining. So even though you're paying for all of it, you don't even get to vote on what they're deciding. And to make sure that they punish you for having an independent mind, they take away your professional liability insurance, make you nice and vulnerable in front of the classroom, which is why we need groups like AAE for our liability insurance. Also, you're not allowed to purchase disability insurance from your employer. I ended up on bed rest for 6 months in a pregnancy, had no disability insurance because I was an agency fee payer. So my little baby and I were vulnerable. Thanks to teachers union, I'm forced to fund. So you're probably thinking, okay, well, no big deal, these fees are small. Well, my husband just happens to be an agency fee payer, non-member, in a university in California. His agency fees are $1,200 a year. No vote, no voice. That seems pretty unconstitutional to me. So I even had a call from a San Diego teacher the other day. She said, because of all these cases at the Supreme Court challenging forced unionism, the union's raising our dues. So all the teachers are paying more because we dare to try to fight for some freedom. I think that's wrong. So I want you to go back to the witch in your mind with me. I want you to imagine that your child is in the witch's class. Or how about your grandchild? Your grandchild's in the witch's class. Well, thanks to collectively bargained grievance procedures, your child's in danger. You as a parent are voiceless. Your voice is silenced by collective bargaining. You have no vote or no voice anymore within that process in the school district. You used to, but you don't anymore. And guess what? The teacher next door, me, the one reporting the abuse, I'm silenced by a union I'm forced to fund. I think that's wrong too. So I know what you're thinking. I'll just move my child, right? I'll take my child to a private school. Well, what if you were poor? Or what if you were lower middle income? What if you were like me? I was a single parent for 7 years. What if you don't have an option? I know, school choice. I'll take my child to the charter school down the road. Well, did you know that the teachers' unions fund a multi-million-dollar annual battle against school choice using the money of teachers like myself who are for school choice and who want school choice for our own children? I think that's unconstitutional. So do teachers really want this union? The unions tell us that. Oh, teachers love us. They want the union. Well, unfortunately, only the teachers' union has a voice. Teachers don't have a voice. That's why we're here today, and we're thankful to you for listening to us, because this is the voice of the teacher. So teachers' unions, I guess a lot of teachers would like it if the union were accountable to us, but the unions get our money no matter what they do. So do you think they listen to us? No. They speak on behalf of the union leadership, not on behalf of teachers like myself who want to protect the children from the witch. So let me just tell you one quick story. I decided to become a full member at one point because remember I had no voice paying those fees. So I became a full member and I served for 3 years as a union rep and a leader on my local union executive board. I was a secretary. During that time, we had our downturn of the economy, and several teachers in my district were going to be laid off. We were told they're going to be laid off. By the way, they were laid off for the crime of being new, Because thanks to teachers' unions, we lay people off based on last in, first out. So you might be the worst teacher in the district, but you have tenure and you've been there a while. You keep your job. While someone who's working really hard, loving on the children, well, let's just say the witch would keep her job. But some really hard-working, loving teacher who just happened to have less seniority would be booted out. Well, I think that's wrong, and it's not good for children. So I fought it, and I said, look, I've talked to the teachers on my campus, and we've decided together, most of us agree, that we would like to take a small pay cut. We thought it'd be only like 3%. To save the jobs of these teachers who are about to lose their jobs. It's a low-income district. Let's keep the class sizes low. That's what the union says is good, right? Low class sizes. Well, I went to the union and I said, look, teachers on my campus, we want to save the jobs of these teachers. We want to do what's right for our community and for our kids. They wouldn't even listen to me. They said the teachers will never do it. I said, do you realize I'm speaking on behalf of the teachers as their representative? We want to do it. Let us have a survey. If 51% of the teachers want to save these jobs, let's do it. They would not even have the conversation with me. Do you know what they finally said to me? Because I was annoying and I kept bugging them. They said, Rebecca, don't worry about those teachers who are going to lose their jobs. The union's going to take care of them. We're going to offer them a seminar on how to get unemployment benefits. And my jaw dropped. Those teachers were paying $1,000 a year for representation, and every last one of them was represented right out of a job, and every last one of their little students and families lost great teachers, while poor teachers kept their jobs. I think that's wrong. I've talked to a lot of teachers across the country, and over 90% of the teachers I've spoken to, they like the local representation of their friends, their teacher colleagues, those who wanted to take the pay cut to save the jobs. They like that representation. They're happy with that. But they resent the state union, and they resent the national union, and they resent all the politics. They resent the one-sided agenda that the unions are using with teacher monies against our wills and behind our backs. We don't know what they're doing most of the time. They just take our money and run. Did you know that of that, let's say my husband's $1,200 a year, did you know that only 20% of that money stays at the local union for the local teachers? 50% goes to the state union. 30% goes to the national union. That's a lot of money. That's a lot of money, and teachers resent that. They don't mind the local, but they have a real problem with that state and national. So in 2012, after I realized I can't make my voice heard within the union without the union, I can't get my district to do anything about this. They're terrified of the union. My administrators were terrified. Nobody would do anything about this. So I started writing editorials in the local newspaper. All I wanted to do was just educate the community and educate my fellow educators on, look, we don't have to put up with this. We could decertify these unions. We can do something. We have to stand up for what's right for the children. That's why we're there, right? We're there for the children. And so I started writing these editorials. And thank God, within 6 months, I had this opportunity to bring a lawsuit, a national lawsuit. And I had the blessing of being the lead plaintiff. So Friedrichs versus California Teachers Association became our case. And we had one just very simple argument, that teachers should be able to decide for ourselves without fear or coercion whether or not to join or fund a union. That seems pretty fair to me. But do you know that the unions took that message and they twisted it and they fought mercilessly? Here's what they did to my fellow plaintiffs and me. They shunned us. They labeled us pawns of the wealthy 1%, as if we were too stupid to think for ourselves. You know, they told teachers, they told my friends that we were trying to ruin the pensions of teachers across the country. I've lost friends over that because they believe the lies. They told everyone we were union busters, even though we were trying to make our local unions stronger. They told everyone we were free riders, even though they're the ones free riding off of us. And you know what? They terrified teachers across the country, but a lot of those terrified teachers came to me in dark closets, or they'd send me a private email, and they'd say, "Thank you, Rebecca, for sticking up for us. Please keep fighting." But they're too afraid to speak up. So this is their voice. They're tired of being abused. So as we headed toward the court, do you know that Kamala Harris, the Attorney General of California, intervened on the case in favor of the unions? And the Obama administration got involved in the case in favor of the unions? These are politicians who say, hey, we're for the little guy. Well, I want to tell you something. I'm the little guy, and all of my teacher colleagues and all my fellow plaintiffs, we're the little guy. And those little kids being abused by the witch, they're the little guy. And these politicians stood in solidarity with powerful special interest unions against the little guy, against those little 6-year-old guys. I find that repugnant, to be honest. On January 16th, we went to the United States Supreme Court in 2016, and we argued on behalf of teachers and on behalf of the safety of children and on behalf of the voice of parents. And you know what? Everyone knew that we won the arguments that day. Even the union knew we won. And do you know what else? Our opponents, during arguments, conceded to our argument that all collective bargaining in the public sector is political. They admitted that. So we knew things went great. But do you know what else? You know, 1 month later, Justice Scalia died. We ended up with a 4-4 decision. But we asked for a rehearing once there would be 9 justices back on the court. And on my birthday, we were rejected. So we lost on my birthday. But you know what? I haven't lost hope, even though we lost on my birthday. Maybe that's a sign. We lost on my birthday, so I should have a lot of hope. Something better is coming for another birthday. Here's why I have hope. There's more cases coming. You're about to hear about the Janus case that's petitioning the court right now. You're about to hear about the Yohn case, which is 8 more brave teachers out of California who basically bringing the Friedrichs case again because I can't bring it again. I would have loved to have been part of it again. But I have another job now. So my job is I'm out educating teachers. I'm educating legislatures, people like you, policymakers. I'm educating parents. I'm trying to help them to understand that, look, we don't have to put up with this. This is America. We can be free. And we're gaining a voice. We're starting to be heard, finally. But you know what? We can't do it alone. So I have a little call to action for you today. We need your help. Could you please adopt a teacher? And I am not kidding. Everybody knows a teacher. There's a teacher in your church or your synagogue. There's a teacher in your family, I'll bet you. There's a teacher in your neighborhood. Please, just 1, 2, 3, 4, 5, a whole bunch of them. Just adopt at least one and do this. Start educating that teacher on the truth. The truth that we can decertify these unions. The truth about these cases, that we should all be fighting for freedom. The truth that they don't need to be terrified all the time. And then empathize with them because they've been beat up. Don't get mad at them if they're afraid. Empathize. They are bullied constantly in a culture of fear that the unions have created on our school campuses. So empathize with them and then empower them. Empower them to learn more, to listen to this little talk or to read about our cases. Because here's why. Here's why we need your help. And this will be my last thought. When teachers are freed from forced unionism, little kids can be safe again in the classroom, and they can learn again. When teachers are freed from forced unionism, parents can have a voice again, grandparents too. When teachers are freed from forced unionism, great teachers can thrive again. And when teachers are freed from forced unionism, America's schools can be excellent again. Wouldn't that be great? So adopt a teacher with me today, and thanks for listening.
Well, Rebecca Friedrichs is a hard speaker to follow, especially when you're going to talk about the relatively mundane legal details of it all. But I will do my best. So as Colin mentioned earlier, about 40 years ago, the U.S. Supreme Court said that governments can force their employees to pay union fees as a condition of their employment. The court said you can't make employees pay for certain union political activities like support for electoral campaigns and things like that, but you can make them pay for their share of the union's cost of bargaining on their behalf. And the Supreme Court thought this struck a good balance under the First Amendment because supposedly, well, nobody would be forced to pay for union politics, but you could prevent workers from what they call free riding off the union's efforts on their behalf. And so ever since then, we've had this scheme where in states that don't have right-to-work laws, government employees, millions of government employees, have been forced to pay money out of every paycheck to a union, either full union dues or what they call agency fees, which are typically slightly less than full union dues. And there are problems with this scheme and problems with the Abood decision's reasoning. One problem is that this scheme that the Supreme Court worked out does not, in fact, protect workers from paying for union politics. One reason why is because everything a public sector union does is political. When a public sector union bargains with the government, it tells the government what it should pay employees, how it should run programs. And that's political speech. If you and I talk to the government about those things, we call it lobbying, and everyone agrees that that's quintessential political speech. So if a government employee is forced to pay any amount of money to a union at all, they're being forced to pay for political speech. And that's something the First Amendment virtually never allows. Another problem with the Supreme Court's reasoning in Abood is this idea that you can force people to pay money to an organization to stop them from free riding off its efforts. In fact, not every worker benefits from a union's bargaining. Some workers think they could do better if they could bargain for themselves. They don't want the union services. They'd like to bargain on their own behalf and be judged and compensated based on their individual merit rather than being lumped in with all other government employees. So when the union bargains on their behalf in their place, they don't consider that a benefit. They consider that to be a harm. Another problem with the whole free rider idea is that even if you accept the idea that unions get every employee more compensation than they otherwise would receive, that doesn't actually necessarily mean that every worker benefits from the union's efforts. As we've seen from what Rebecca said, there may be situations where particular employees don't want more compensation. They'd rather get less compensation and have more people employed because they think that's fair. Or like our client, Marc Janus, he works for the state of Illinois as a child support specialist, and he thinks that the union he's forced to support is partly responsible for the fiscal and economic disaster that is the state of Illinois. He thinks that Illinois is in the bad shape that it's in because of unreasonable demands that his union has made over the years. And he thinks it would be wrong to ask taxpayers to pay significantly more for employee salaries when the state's in the bad shape that it's in and people in the private sector are hurting. You know, the union's argument assumes that everyone is only concerned about their own narrow pecuniary self-interests. But that's not true. Lots of people care not only about themselves, but about their neighbors, their communities, their state's economy. And so they don't support more for themselves if it means imposing an unfair burden on other people. And so when those people are forced to fund advocacy they disagree with, they're not free riders, they're forced riders. Well, the Supreme Court has, as Colin mentioned, recognized these problems and others with the Abood decision, and it signaled at least the conservative justices have signaled that they would be willing, might be willing, to reconsider the Abood decision and overturn it if the right case came along. We thought that would happen with Rebecca's case, but as she said, that fell through when Justice Scalia unfortunately died after oral arguments. But fortunately, our case was already in the pipeline when Friedrichs was before the Supreme Court. And our case started when the governor of Illinois issued an executive order directing state officials not to take union fees from anyone who wasn't already a union member, because he said that would violate their First Amendment rights. And at the same time, he filed a federal lawsuit asking the federal courts to declare that the First Amendment required him to do this. The unions and the Illinois Attorney General responded to this by saying that the governor didn't actually have standing to bring this lawsuit because he was never forced to pay union fees, so he has nothing in it personally. When we saw that, we, together with, at the Liberty Justice Center, together with attorneys at the National Right to Work Legal Defense Foundation, moved to intervene in that case on behalf of several Illinois state employees who had been forced to pay thousands of dollars to a union against their will over the course of their career. And the court then let the case go forward without the governor, but with our plaintiffs. And now that it's down to just one plaintiff, Marc Janus, a child support specialist who has been heroic and incredibly brave in standing up to AFSCME, which is, of course, one of the most powerful political forces in the state of Illinois. The timing of everything was very fortunate for us because we were in a position to petition the Supreme Court to take our case in June, which was shortly after the Supreme Court got a new ninth justice with Neil Gorsuch. And so now the court's in a position to take this issue up again. And we're hopeful that it will grant our petition as soon as it comes back for its new term in October. Of course, you can't predict what the Supreme Court will do, but you'd think if they wanted to resolve this issue in Rebecca Friedrichs' case, they'll still want to do it now. And we're hopeful that if all goes well, the court will issue a favorable decision by the end of its next term in June, which will mean that by this time next year, every government worker in the country at every level of government will be free to choose for themselves whether they want to give any of their money to a union. That will be an incredible victory for worker freedom if it happens, but it won't be the end of the story because there will still be other things that will have to be done to ensure that unions and governments actually respect employees' rights. And to talk about that, I will hand things over to our next speaker, Terry Pell.
Well, thank you, Colin, for organizing this, and thank you to the Heritage Foundation for hosting this. Jacob talked to you about a case that he hopes to get to the Supreme Court this term that asks the court to end compulsory dues nationwide in the 22 states that now have them. If he's successful in getting the court to take the case, we expect that by, as he said, by this time next year, compulsory dues will be a thing of the past. The court will have ruled that it is unconstitutional to force employees like Rebecca to pay even agency fees to support the union. The case I'm going to talk to you about is the next logical step after Janus. It's a necessary next step in making the choice to support unions truly voluntary. It is necessary because the unions are actually not likely to simply give individuals the right to decide whether they want to join the union or not. We know that unions are determined to keep their members. They, through the agency fees, get millions of dollars each year in revenue that they don't have to do anything. It just shows up at their doorstep. And so it would not be unreasonable for them to try to keep as many members as they can and to interpret whatever decision the Supreme Court releases this year in as narrow a way as possible, in a way that benefits the unions the most. So what are the unions likely to do? Well, they'll say, okay, we get it. Compulsory dues are a thing of the past. But guess what? all of our existing members have already elected to join the union and have already voluntarily decided to pay these dues. And so we're going to assume that they want to continue to pay these dues until they tell us otherwise, until they leave the union or opt out of paying further dues to the union. Now, you might think that it's an easy thing for somebody to leave the union, but that isn't so. The union can impose rules for when you can leave and what you have to do to leave. It can say, for example, that you can only opt out of union membership once a year during a narrow 2-week period. And it can put that 2-week period in the first month of the school year when teachers are generally going crazy trying to get organized for the new year. And it can hide the rules, the deadlines, the timelines, and the various procedures you have to follow. It can hide those rules somewhere on a website that teachers have to go looking for or hear about by word of mouth. And then there's another thing the unions can do, which is even more troublesome. The unions can say, well, it's not enough to just leave the union once. We're going to assume every year that you want to be a member of the union unless you tell us all over again that you want to opt out of union membership, according to the same complicated rules and procedures you had to use the first time. Well, how likely is it the union will put all of these barriers and impediments on people's ability to leave the union? Well, it's very likely. The unions already attach these conditions to the ability of employees to become agency fee payers. When Rebecca became an agency fee payer, she had to file a letter with the union and then follow up with a refund request for dues that she'd paid. She has to make that refund request every single year within a narrow time period, which generally falls in the beginning of the school year. So there's no reason to think that the unions won't impose these kinds of conditions on the ability of employees to decide they want to leave the union. So the case that we at the Center for Individual Rights have brought would change all of this. We're asking the court to strike down these opt-out rules and replace them with an opt-in system, where our case asks the court to rule that these kinds of impediments amount to an impermissible burden on the free speech rights of individual employees. And if Jason wins his case, the court will have said that everybody has a First Amendment right to decide for themselves whether to join the union. Well, in that case, the union can attach all sorts of conditions to the ability of employees to actually exercise that right. And we're asking the court to strike down those conditions. So just to be clear here, the right that we're talking about and the right that our case defends is the right to remain silent, the right for teachers to decide on their own whether they want to join the union, and to not have to go through the procedure of deciding not to join the union. This kind of right to remain silent, to stay out of the public discussion, is in some ways the opposite of the normal free speech right that most people think they have. Everybody understands that they have a right to speak out without the government censoring them, but not many understand that part of that right is the right to not speak out, the right to remain silent, the right to decide for yourself when and how to participate in public discussions. So in our case, in Yohn v. CTA, we're fighting for the right of teachers to not have to join various public discussions that the union would like to have, and instead to opt out of all of those discussions, to not participate in any of them. We're asking for the right of teachers to remain silent, to not be a participant in these public debates. Well, the right to choose for oneself under what circumstances to participate in public discussion runs current to everybody's general understanding of why free speech is valuable. Most people think that free speech is justified because free speech leads to a discussion and an open discussion in a marketplace of ideas, which allows us to see which claims are true and which claims are false. But a right not to speak doesn't really contribute to the marketplace of ideas. It allows people who might have very important points of view to make to just sit back and remain silent. So that's why this right is not particularly well understood. But the truth is that, like many other rights in the Constitution, the First Amendment is not so much designed to achieve a perfect marketplace of ideas, but to prevent an abuse. Specifically, is designed to prevent the government from coercing speech. So that means that individuals, not the government, get to decide not just what to say, but whether they want to say anything at all. It's not up to the government or the unions to decide that we have to have a perfect marketplace of ideas by requiring everybody to pay to participate in a large public discussion managed by the union. It's okay under the Constitution for an individual to say, I don't want to participate in that conversation one way or the other. So in the context of the union dues case, the right not to speak means that nobody should be a member of a union unless they affirmatively decide to join. They're free to refrain from taking a position one way or the other on the myriad of issues that the union wants to talk about. We're representing 6 teachers in California and the Association of American Educators who have a variety of views about unions. Some of our clients in this case think that unionism is generally a good thing. They just don't happen to like the California Teachers Association and the NEA. They think those unions do a bad job. Others of these clients don't like to be part of a union at all. They disagree with the idea of unions. They disagree with the fact that these unions have become highly political organizations and they want nothing to do with it. What joins all of these plaintiffs together is that they think each of them as individuals should have the right to decide whether to participate in the union in the first place. They're saying that individuals have a constitutionally protected right to not speak, and that they shouldn't have to run around and comply with various opt-out rules in order to exercise that right. Instead, the burden ought to be on the union to run around and encourage individuals to join the union on their own terms when and if they want. So if the court decides in Janus that unions may not charge agency fees, it will still be important to settle the conditions under which employees can exercise that right, whether they can exercise the choice to join or not join the union on their own terms. Our case asked the court to put that choice firmly in the hands of individuals by respecting their right not to have to make a choice, to respect their right to remain completely silent on the question of on the issues that the union wants to talk about. So you might want to think about our litigation, the litigation of all of Jason's firm and my firm, as a kind of chess game. At each stage, it's necessary to kind of think forward to what the next step, down the road is going to be. So if Jason wins his case, then the next step is going to be trying to satisfy the conditions that are necessary to make the choice to join the union truly free and not coerced in any sense of the word. Thank you.
Thank you. Well, I want to thank the speakers for being time conscious. We have, I think, 5 minutes here for some questions. We have, John will come around. There's a speaker, is the microphone working? Oh, we have a couple of them. Andrew also. Raise your hand if you want to ask a question, and if the mic comes to you, please state your name and any affiliation so the people watching online and listening on C-SPAN can hear. We have questions? Yes, thank you.
Mal Klein, Accuracy in Academia. I just got a really mundane one. This is for you, Colin. Could you lay out exactly how many members you got and what benefits they exactly get?
Sure. We have over 20,000 members throughout the country. And the reason that teachers join the Association of American Educators is they get a $2 million liability insurance policy along with employment rights coverage. So they get to work with an attorney when there's a job action. That is in lieu of what people would usually get from the union. But a significant difference is that coverage is actually guaranteed as a part of the liability insurance benefit, whereas with the union, despite paying all those dues, and you paid them for some years, there's actually no guarantee to provide you with that protection. So that's the most significant benefit. And there's other traditional professional association benefits and more information on aateachers.org.
Thank you. Next question down here.
Hi, my name is Marc Janus. I work in the Senate. I wanted to ask if the sort of rights and freedoms that would be won by these lawsuits would go beyond the what's protected under right-to-work laws in the 28 states, or however many there are that currently have those in effect.
Who wants to, okay, Terry?
I mean, I think if if the court agrees and strikes down compulsory dues in Janus, essentially it makes the entire country a right-to-work country. So the rules in particular states may vary, and there are obviously going to be fights afterwards, you know, in our case, for example. But the general point is that the entire country will become right to work with the stroke of a pen.
Hi, I'm Kevin Mooney with the Daily Signal here at Heritage. The Harris V Quinn decision, the unions have made every effort to undermine that ruling, and I think the big takeaway is there are people, strictly speaking, under current law who are paying dues who don't have to pay dues. So if we do get a Friedrichs-like decision, being optimistic about it, to me that's a beginning and not an end, because the unions will work with their allies in government to try to gut that ruling, just as they've done in Harris v. Quinn. And Rebecca, I think you know that your partners out there in SPN and Washington State have been draining the membership rolls of the SEIU by educating people about their rights. So I hope that we don't sit back passively if we win legally.
I'd like to just address that quickly. That's precisely why I asked you to adopt a teacher. Because even if the Janus case wins and the Yohn case wins, and then teachers have the right to opt in rather than opt out, they will be bullied for taking that stance. If you have an independent mind, the unions supposedly stick up for women's rights and all this stuff, but they punish me constantly for having an independent mind. So these folks will be bullied, they'll be shunned, they'll be isolated. There's a lot of ignorance where people can't figure out how to do it. So it's just the beginning. We have to keep on fighting. We can't relax once these cases, if these cases are successful. Thanks, Kevin.
I think this would be the last question. We have 1 minute.
Joel Mandelman, I'm an attorney here in Washington. When you just said that if you won the case, you'd have, in effect, the national right to work law, this decision, no matter how favorable, wouldn't affect private employers, would it?
No, that's true. That's true.
Right.
This is limited to public employee unions.
Okay.
Which is the majority of unionized Americans.
All right. Well, I want to thank you all for showing up and for watching online and on cable. And I want to thank the panel for being here. Thank you very much.